U.S. workers tend to be more sensitive to DEI issues than their non-U.S. counterparts. What should an employer with U.S. and non-U.S. workforces do about this?
Non-U.S. workforces, such as those in Asia or Latin America, often have to interact with their colleagues or customers or partners in the United States. Indeed, non-U.S. employees of multinational companies are in frequent cross-border contact with their American counterparts, either via Zoom, telephone calls, emails, or in-person meetings.
These cross-cultural contacts can be risky because sensitivities on certain issues can differ dramatically between America and other countries. Diversity, equity, and inclusion, or DEI, is now a prominent aspect in many workplaces in the United States. As a result, there are heightened sensitivities among American workers about the rights of women, LGBTQ+ communities, minority ethnicities, and other groups.
Therefore, it is essential that non-U.S. workers understand these U.S. sensitivities and do not intentionally or unintentionally insult or offend their American colleagues. Not only does this lead to hurt feelings and low morale in your global workforce, it can lead to real legal risk in the United States.
Even a comment from a non-US worker that their American colleague finds discriminatory can result in an internal complaint, or even end up in a discrimination or harassment complaint that is filed before a US government agency or court, or be uncovered during discovery and litigation.
Some of these instances that lead to this type of risk are sadly familiar to many of us. For example, an APEC worker at an American company was overheard asking his colleague if the American manager who was on the Zoom call was, quote, a gay, unquote, raising the risk of a sexual orientation-based discrimination or harassment claim in the United States.
As another example, an APEC worker whose country has a retirement age for private sector workers may express to their American colleagues that older workers should retire, raising the risk of an age discrimination claim.
As yet another example, a Brazilian worker who visits the U.S. office for the first time may try to greet his American colleagues with a hug and a kiss on the cheek, which may be customary in Brazil but can make the U.S. workers, especially female workers, uncomfortable and lead to sexual harassment claims.
As yet another example, a US worker felt their Eastern European colleagues were reluctant to use their preferred they pronoun. It was unclear, however, whether such behavior was intentional or simply attributable to the non-US workers' weaker command of English as their non-native language. But this situation could nonetheless raise the risk of a discrimination or harassment claim based on gender identity.
So training non-US workforces on DEI sensitivities in the US is essential. And that's why we have put together a training task force of little attorneys who were raised outside the US, but who have practiced law in the US and therefore understand these US-based DEI sensitivities and how they play an increasing role in discrimination and harassment claims.
Hi, I'm Renata Neeser, and I was born and raised in Brazil, and I practice law both in Brazil and in New York City for the past 20 years.
I am Marcin Sanetra. I was born and raised in Poland, but have lived, studied, and worked in the US as an attorney, admitted to practice in New York.
I am Tanaka, and I was born and raised in Japan and have practiced in Japan for over 10 years and in Boston for 10 years.
And I am Lavanga Wijekoon. I was born and raised in Sri Lanka, worked in India, and am now practicing in Chicago. And together with Aki, Renata, and Marcin, we train our clients' non-US workforces on how to deal with the differing workplace sensitivities of their American colleagues, clients, and partners. And we are here to help you deal with this cross-cultural employment challenge.